topic today that I think a lot of people have been interested in hearing more about, and hopefully Dr. Heinemann can shed some light on it for us. So, Dr. Heinemann is here. He graduated from the University of South Dakota for undergraduate and medical school, then went on to complete residency in family medicine here in Sioux Falls, and then has gone on to have a long career, 37 years of experience in practice, policy, and administration, both in South Dakota and in national office. So he's served as the South Dakota Academy of Family Physicians as a board member at both the state and the national level, and is currently serving as the SDAFP lobbyist. So, Dr. Heinemann.
Thanks, Carolyn. Good afternoon. I know there are a variety of sites on. I want to try to get through this information so that have a chance for people to ask questions. So we're going to talk about medicinal cannabis. Now that it's legal, what do physicians need to know? And these are some of the objectives that were sent out. We'll talk a little bit about all of these things, but primarily want to be able to also try to answer your questions. I have no conflict of interest. I own no stocks in any cannabis companies. You can invest in cannabis companies. There are exchange-traded formats that you can invest in those. But I will also tell you that I have zero experience using this medication in practice. When I left practice, this was the last thing anybody would talk about. When I spent some time in administration, worked with physicians in Minnesota and in North Dakota where it was becoming legal to use it. So I have some experience there. But the primary goal of today's talk is to tell you what the law states and how you can expect to see what's going on. Cannabis in medical form is now legal in 36 states and these territories and the District of Columbia. I checked last week. I don't believe there are any states that passed it recently to change. South Dakota did so, interestingly enough, just last November. And it was the only state and the first state to both legalize or have legalization of both adult recreational cannabis and medicinal cannabis on the same ballot initiative. Legalization of medicinal cannabis came about through initiated Measure 26, and we'll talk a little bit about that. The constitutional amendment legalizing adult recreational cannabis in South Dakota is still in the courts. Several law enforcement officials took the constitutional measure to court to say that it's an illegally drafted constitutional amendment and therefore should not go into effect. We're still waiting for the South Dakota Supreme Court to rule on whether or not there will be adult recreational cannabis in South Dakota. The technicality that they are arguing is that a couple of legislative sessions ago, the South Dakota legislature passed and the people voted on only allowing one topic to be part of an initiated or constitutional amendment ballot issue. They're claiming there were two issues on the constitutional amendment around recreational adult marijuana, had to do with both legalizing it and figuring out a way to tax it. And so on that technicality, they've taken it to the Supreme Court. Lots of people felt that there would have been an opinion rendered by our state Supreme Court. It's not there yet. Waiting for it on any day, and then we'll know whether we have to deal with both recreational adult marijuana as well as medicinal cannabis in South Dakota. Let me just give you a little background about this plant. It's been around a long, long time. It's indigenous to South and Central Asia. It's probably one of the first plants ever cultivated by man. And it wasn't necessarily for its psychoactive properties, but more for its fiber and its nutritional seeds. And we've, in South Dakota a couple of years ago, our legislature did approve the growing of hemp, industrial hemp in South Dakota. And that's when you started to see a lot of CBD stores, because CBD is gotten from hemp. And primarily it is a low yield for THC, but high in CBD. THC stands for tetrahydrocannabinol, which is the predominant psychoactive component in these strains of these plants. But hemp plants also have a lot of CBD, which you now see is great for everything from your arthritis to your migraine headaches, and it's available in lots of places. And there are CBD stores now. Cannabis contains hundreds of distinct compounds. But the medically important compounds, and I'm not here to spend the next few minutes talking to you about these, but I just wanted you to know, are THC and CBD in varying percentages. My other conflict that I should have said is I'm a college student of the 1970s, and I can assure you there was stuff in the air when I was at parties and a variety of places. Yeah, unfortunately I would have trouble probably running for public office. But the point of that is the cannabis of 1970s is not the cannabis of 2020. Been a lot of selective growing of cannabis, and so the plants that you see today are highly selective in either their production of THC or CBD. And these, again, THC, delta-9 tetrahydrocannabinol, that's the psychoactive and probably the best studied, but the most controversial of the chemicals that are in this plant. And then CBD or cannabidiol, not psychoactive. In fact, in some references, you'll see it might actually mute the effect of THC, but not extensively studied until now because of the issue. This is actually a pretty good reference. I bought this a few years ago when I was working in policy and as a medical officer in Sanford, because I had responsibility to locations in Minnesota and North Dakota. And it's really good. Unfortunately, it's actually written by one of the physicians who has an ownership stake in one of the companies that provides cannabis products in Minnesota. So, but it's actually a pretty good primer for some of the medical components. And it's available on Amazon. I think it's either $29 or $39 for the book. But it is still available to be purchased. The problem with cannabis is there's not a lot of good medical research out there on the uses. If you've seen one cannabis program or one state's program, you've seen one state's program. The other thing that I want to talk about here is, remember, this drug is still illegal federally. It is still a Scheduled I drug. Just like LSD, methamphetamine, it is still a Schedule I drug. So it's hard to do research on. You cannot prescribe this drug. It's not a prescribable medication because it's Scheduled I. If you have an electronic medical record that helps you with drug interactions, it's not in the drug interaction database because it's a Scheduled I drug. And so you can't run THC or CBD against whatever drug you want your patient may be on to see what the drug interactions are. It's never been really well studied to know what the drug interactions are, and that illegality federally has some complicating factors if you're working in a hospital or a long-term care facility or any other facility that is regulated by CMS and the federal government. You just shouldn't, it should not even be in the facility, which is going to create real difficulties for clinicians who now are admitting somebody to a long-term care facility who's been using cannabis at home for one of the recognized medical conditions. It's going to make it very difficult, if not impossible, to use in the facility because you can't order it, you can't prescribe it. People will have to use it clandestinely. It's just crazy. Now, there is a movement in the United States Senate, been brought by a few senators, to reschedule cannabis at a federal level, probably down to Schedule 4 or 5 maybe, to where it can be. And there is now actually a drug, Epledex, which is derived from cannabis. It's not a, Marinol has been out there for a number of years, but it's a synthetic. Epledex is actually taken from cannabis plants, and it's used in the treatment of Dravet's and rare seizure disorders in children especially. And it's out there now to be prescribed. South Dakota, the South Dakota legislature a couple of years ago kind of did reschedule THC if the feds changed theirs. So every year there's legislation to look at the various scheduled and what other drugs are out there. And lately it's been Creighton, a bunch of other kind of weird amphetamine type drugs that they've been recategorizing. Iowa has a CBD cannabidiol program. It's mainly aimed at CBD for the treatment of a few medical conditions. It's highly regulated, really kind of a different program, and aimed mostly at the treatment of pediatric seizures. Minnesota has had a cannabis program for a number of years, totally different than anything in our region. There is no ability to have whole plant product in Minnesota. Minnesota, their legislature saw that the handwriting was on the wall, that they were going to get an initiated measure or patient or citizen-driven cannabis laws. So they passed some legislation to allow cannabis to be used medicinally, but it's an extracted product. There are two companies in Minnesota that actually extract through gas chromatography technology the THC and the CBD, and then it is available in dispensaries around the state of Minnesota. And a pharmacist at the dispensary will give the patient who's been registered and has received permission to have this product in their possession, whether they need the THC, maybe for more nausea, other types of work, or a higher percentage of CBD. And it's usually like a 75-25, 50-50, 25-75 kind of product. The problem with that, and you hear a lot of complaints from Minnesota citizens, is it's very expensive to get that kind of product. And Minnesota has had an office of cannabis in their Department of Health for a number of years. They also, when they did the legislation, outlined a minimal list of medical conditions that you can certify a patient as having, but a process of adding those, adding conditions was also available. So Alzheimer's disease and autism spectrum disorder have been added. Sickle cell disease, I would imagine it's for the pain of a sickling crisis. But rather some strange things have been added. PTSD has been added as citizens petition the Department of Health, and the Department of Health has added it. You know, originally a lot of times people talked about glaucoma. Well, you almost have to be high all the time in order for cannabis to really affect your glaucoma, and there are a lot better glaucoma medications out there than using cannabis. North Dakota, again, it was an initiated measure. The citizens told the state that they wanted cannabis. The North Dakota legislature tried to overturn it. Couldn't be done. Took them a year, but now you can, if you can't get to a dispensary a reasonable distance, you can grow it on your own. So again, you've seen one cannabis program, you've seen one cannabis program. So initiated measure 26, almost 70% approval by the voters in South Dakota. But it's not very popular with our elected officials. And it was coupled with adult recreational constitutional amendment. And it's yet to be seen where we're going to be at with that. These are some of the qualifying conditions that you see. These are the ones that are listed in the legislation. Now, let me explain to you, as before we get into the rules, what happens in South Dakota with regards to laws. Okay? So this initiated measure said we want medicinal cannabis in South Dakota. After that November election, there was a lot of posturing by our legislature about whether or not we should even do this, because the legislature is far more conservative on this issue than the citizenry was when it came to passing these measures. So the legislature did have to, because it was passed and it was going to become law, create a new chapter in the chapter related to public health, chapter 36. So it's chapter 36-20G has all of the stuff related to cannabis. So once a law is passed, then the way a law is used or enacted or impacts people is that rules have to be made. And typically what happens in a piece of legislation or in a chapter, it gives the department that's the one in charge, in this case the Department of Health, the ability to what's called promulgate rules. So rules have been written, and it's 113 pages, the rules that have to do with medical cannabis, and it's Article 44-90 are the rules. Now, the bulk of these pages actually have to do with dispensaries and testing of make sure there are no pesticides in the cannabis that people are getting, et cetera, et cetera. So the rules process actually just started with a public hearing on the 18th or 19th of August. They had their first public hearing, and so that process now is working to get the rules. So I'm going to go through some of the highlights that you need to understand about the rules. So the rules haven't been completely delineated yet. They're in the process of being written. The state has and has said they will, in November, have the process available to allow physicians to begin to certify and get cards. So what's going to happen? You as clinicians will be asked by patients who want to seek out and use medicinal cannabis to certify, and that list that was back here is the starting list of conditions. So if I have debilitating pain, I come to Dr. Brechtelsbauer, because I just saw David sitting there. And David, I have debilitating pain. I think cannabis would be a really good thing for me to have. Well, the way the statute reads is that Dr. B needs to, one, diagnose that I have debilitating pain. It's debilitating. And that cannabis would probably benefit me other than some of the other treatment we've been trying for my debilitating pain. And then I would get a card that says I've been certified to use medicinal cannabis for my debilitating pain. Now, where do I get it? If you've been paying attention to the news here in Minnehaha and Lincoln counties, the city of Sioux Falls, the county of Minnehaha, and the county of Lincoln have been trying to figure out how many dispensaries they're going to allow in Sioux Falls. And they're talking about fewer rather than more, very restricted. The state has a process in here to get a license to be a dispensary, what it means to be a dispensary, how you have to test, what you can do, etc. However, the other piece that's rather problematic for physicians is that there is a home grow option in this legislation and in IM 26. I can't get to a dispensary, and this is the real interesting piece, and my physician says I can grow at home. So doctors right now are going to be on the hook for this home growing business, and I'll talk a little bit more about that in a second. Then I can grow 3 plants at home. Now, the other interesting thing for physicians, if I can convince my doctor that I need more than what 3 plants can give me, I can get permission, if my physician agrees to it, that I can grow 6 plants at home. Now, if you've paid attention in the last 24 hours, the legislative work group that's been working on this has said, we don't like this homegrown option because there's too much black market stuff that happens. Too much cannabis is going to make it into the hands of people that shouldn't get it or don't need it. So next legislative session, we're going to try to get rid of the homegrown option. Now, I will tell you that most medical associations don't want physicians to be in this quandary about whether I should get 3 plants or 6 plants or homegrown at all. They're really worried about, and so the South Dakota State Medical Association has been very active in this whole rules process. And their representatives have been at the rules hearing. You can go out on this Department of Health website. If you have an hour and a half of time you can't use for any other purpose, you can listen to the rules hearing. And a lot of it's about the growing, it's about the dispensaries and all of that. But it, again, is very problematic. And the organized medicine wants to disconnect physicians from this process as much as possible. I know in physicians that I worked with in the state of Minnesota initially wanted nothing to do with it. And part of the problem was patients who wanted to use it were struggling to find physicians who would certify that they had one of the conditions. So the real fear is that all of a sudden now the state's going to make some of this contingent, your license contingent on you at least taking. And who knows what could happen if another initiated measure came about for our elections in 22 that said physicians must see people who want cannabis and must help them with it or whatever. I mean, anything can happen. Anything can happen, especially when you're in where we, if our legislature maybe it had taken the bull by the horns a couple of years ago and said, yeah, we'll design a program, but they didn't, and so therefore the problems that we have are here. Again, cannabis is still Scheduled 1 usage in hospital and elder care facilities. Now, the other thing, and I had a conversation with some folks in the Medical Association earlier this week about this, and it's been seen in Colorado. So now you have a lot of states went to medicinal cannabis first, as seen like a more reasonable way to kind of broach the whole legalization of cannabis issue first. And then they kind of got used to it, then they got the recreational. Well, what happened in Colorado first was when they got adult recreational, they saw the requests for medicinal cannabis drop a little bit until people started looking at what it costs. Because even in the constitutional amendment here in South Dakota, they're going to make revenue out. The state's going to tax this, and they're going to tax it pretty well. I mean, it's going to be a revenue generator. And what happened was the product got so expensive for folks who needed it for what they called legitimate medical reasons, then started going back and accessing this through the medicinal cannabis portion of the legislation, because it's not taxed when it comes with when it's medicinal. So again, the other thing is the legislation and the initiated measure recognizes cannabis cards from other states. So if I've got one from Minnesota, I can bring it over and I can get product here in South Dakota. But remember, I told you, you better not have a whole plant on your per person. If you get stopped in Minnesota and have a cannabis card, you can use it probably in South Dakota, but you better not have it in Minnesota, because you could get arrested for possession. The other thing that's going on in a lot of these cases is there is kind of a federal, I'm putting my hand over my eyes if you can't see me, kind of aspect to this. In the Obama administration, there was something called the Holder Letter, where the Attorney General told his U.S. attorneys, if a state has legalized cannabis from a medical perspective, we're not going to be as aggressive in prosecutions for somebody that maybe holds a medical card, even though it's illegal federally. They weren't sure what the Trump administration was going to do. So it is a flip of the coin. If you got cannabis on your possession and you get stopped transporting it across state lines, you do not want to be caught with cannabis in your system if you're a truck driver, a bus driver, you're a federal employee of any way, shape, or form, because it's just not allowed. This whole idea of having a physician decide whether you should have 3 plants or 6 plants, I mean, again, it wasn't, the initiated measure wasn't necessarily written very well. You can have up to 3 ounces. And then the other thing is, you either smoke it, you eat it, or you rub it on your skin in South Dakota. I mean, there's no pill form. In Minnesota, there's pill, tincture, and vaporization type product. But in South Dakota, you're either going to eat it, and most people would say that's not a very reliable source, because I can eat a whole bunch of it, I haven't had the effect, so now I eat a whole bunch more, and lo and behold, it kicks in, and I've really got a lot in my system. Nothing good comes from smoking anything. And when you vaporize it, you've got all those other chemicals in there, and who knows what, if anything, they will do. So again, it's just not perfect. And the law that says, again, cachexia, wasting syndrome, debilitating pain, nausea, seizures, severe and persistent muscle spasms consistent with MS. And they're in the process, in the rules, they may expand that list a little bit more. I know any all the representatives from all the professional organizations really want it to be debilitating, severe, kind of end stage stuff. So I talked a little bit about the rules and the process, talked a little bit about the interaction between adult recreational and medicinal cannabis and what might happen, could become another revenue stream. There's a lot of taxes collected on this product in Colorado. And it's the other thing, the part of the problem is also it's a banking issue because banks are prohibited federally from taking dollars related to cannabis sales or drug interactions and all of this stuff. So it's become a huge cash industry. And there's a lot of cash around in this. So crime is up related to that. And the state has agreed that it will probably by November be ready to start issuing cards to patients who qualify. So I can't today tell you exactly what these rules are going to look like. We have a pretty good idea. People also ask, well, how can the tribe up at Flandreau do this? Well, tribes are allowed, anything that anybody else is allowed to do in the state, tribes are allowed to do it. And from what I understand, the tribes have hired clinicians from outside of South Dakota to do virtual visits and certify people, and they can then go to their dispensary and get the product. They're earlier in the year, the state was saying we're probably not going to be as aggressive in prosecuting people who have very small amounts that say they've got it for medical reasons, but it's still very much up in the air. But the law that allows this to happen went into effect July 1. And so that's why there's now all this work with the rules. The rules hearing happened. They took input. The Department of Health will then rewrite the rules. They then need to go to a legislative oversight committee, which will say, we like these rules or we don't like these rules, go back. But the clock is ticking that they need to get it done because there were some prescription and time in the initiated measures. So that's kind of where we are today. In September of 2021. So stay tuned. I think if you work specifically in a hospital, you probably are going to be able to avoid it, although you might see patients that have come in that are using it at home now want you to figure out a way for them to use it in the hospital. And it might be to show them where, if they're ambulatory, how to get out of the building or whatever. Because nurses can't touch this stuff. You can't prescribe it again in the hospital. And we don't know where it's at. Does this work? I don't know that we know. It's empirically you hear about people that have benefited from it. We know that it works in some of those children with those severe seizures. And the downside is we haven't done enough research, collected enough data. Part of the Minnesota legislation was that people have to report back adverse effects, beneficial effects. So the Minnesota Department of Health has been collecting that data, but I haven't seen anything published from them at that point. So I'll be happy to try to answer any questions. I hope you have a little better understanding of what's going on in the process. I don't know where we're going to end up. I suspect physicians may get kind of disconnected from this whole 3 to 6 plant process in the rules, but they would be violating the initiated measure until the legislature passes some more laws in the session in 22 to kind of clarify some of that. So happy to answer any questions from any of the outlying sites or here in the room. So stay tuned. And like I said, yesterday I heard this this homegrown issue, and it passed that issue. I think it was 5-4 in the committee that they want to revisit this homegrown issue and with legislation in the next legislative session. So might be able to grow till next July, and then that will change as well. So, yes. Laura, there will be a process, and there'll be forms that are not out there yet, but they'll be delineated in the rules and will be generated and developed by the Department of Health. So you'll be able to go on the Department of Health website and download the form that you'll need to fill out for your patient. They may even come in with the form. I know in Minnesota, physicians were asked whether or not they wanted to register as certifiers so that the Department of Health had a database of clinicians that were willing to at least see patients to do the certification. I don't know if that will be the case. I know it's not required in any of the legislation, but there will be forms that will be drafted and available so that you'll be able to download them, or your patient can download them, bring into you, and then you'll fill out, and then they will send those in. There is a fee. There's a $20. There's a fee, and if you're low income, the fee is less than if I think it's. I want to say it's $75. I was going to write it down and I forgot. But there is a fee, but the fee is significantly reduced to $20 for people who are low income or on Medicaid. So they did that, but there is a fee that the patient will have to pay on an annual basis to be able to continue to be certified. Did that answer your question, Laura?
Yes, it did. I had one follow-up question to that. So
Can you speak up just a little bit? We had a hard time hearing your question.
yeah, can you hear me better now?
A little bit, yes.
Okay. My next question is there a way to withdraw exclusion? So if I find that a patient is certified and I think they're using inappropriately the way that I can take other controlled substances away, is there any way to report someone who might be certified or withdraw?
Yes, there will be a process by which, if people are abusing abusing their right to have this, that you can ask that their certification be rescinded. It won't be in the prescription drug monitoring database because it's not a prescription drug, so it won't be in the PDMP as a required reported drug as of this time. And I don't know of any states. I think people have tried to get it to be reported, but nothing that will be required of you to submit it to a prescription drug, if you will, database. But there will be a process by which you can say, hey, I don't think this person's, it's the right thing anymore. So.
Dr. Heinemann.
Yeah.
I kind of envision a similar system as we currently use for the handicapped placards.
Yeah.
You know, you've got the conditions that we mark off on. Do you think that we will also, if we certify these cards, we would have the ability to choose temporary versus permanent, 3 months, 6 months, 1 year? How often will they recertify? Do you have any sense of what the rules are leaning towards?
Most places, most jurisdictions, it's a year. I haven't seen anything shorter than a year. The concern is, driving while under the influence of these substances. I was wondering if you were going to go that they had to have a little sticker on their car with a cigarette and a flame, smoke going up under the influence or whatever. I don't know.
Okay.
And that's another concern that clinicians have. it's one thing that, we have the ability to measure the amount of ethanol in your bloodstream. They can measure cannabis. Will there be a cannabis test that'll be out there in the future? I don't know. And, like I said, it's a cash business. Tends to generate some crime related to the fact that it's a cash business. So I don't know. It's going to be really new territory for clinicians starting in November.
And do you envision that systems will need to renegotiate their chronic controlled substance contracts? I think Sanford's currently dictates that marijuana cannot be found in the system.
I know before I left my role that one of the pain clinicians that did a lot of pain work in another community in Sanford was had started using cannabis more than this individual thought they would need to when it first came available in Minnesota. I know the comment's been made by this clinician. I was able to reduce the number of opioids the patient was taking. And it's really pick your poison. And so I think that there will be a need to probably make some concessions in certain situations. If you don't have a cannabis card and cannabis is found in your system, that's a breach of trust with regards to that kind of a contract. That's that whole contract pain agreement process is really about a level of trust between you, the clinician, the prescriber, and the patient, the recipient. I'm not going to mess around with this because this is risky. And that's really what that's about. It's kind of a documentation of trust. And I don't have other substances in my system that I haven't told you about. So I suspect now that will be. I pulled the current Sanford policy. I don't have access to the Avera policies, but it speaks to a lot of that. And it's the intricacies of the whole CMS, hospital prescribing, patient using it in the hospital, long-term care is yet to be figured out. So, any other questions? Jenny can probably, if you need something from me, I'd be happy to give it to you. I don't have all the answers, and I'm certainly not an expert in whether or not this stuff works or prescribed. I just know what the process is, and I know where we're at right today. But stay tuned. And I know the South Dakota Medical Association on its website is going to try to keep, and I know that the South Dakota Academy of Family Physicians, and I got to believe the College of Physicians and the PEDS organizations are going to try to keep its members as up to date as possible. But I know the SDMA is working a lot on this, and I talked to Mark and Barb earlier because they had a representative at the rules hearing, and they're trying to get the physicians kind of out of the box that they've been put in by some well-meaning citizens that wrote IM 26.
We have some residents in the audience. Does the South Dakota law dictate you have to have a full license, or can you prescribe or write a card with a training license?
It doesn't say that, but I'm glad you asked that. I meant to point this out. It's only physicians right now.
Yeah.
It's not nurse practitioners or PAs. So I would assume it says fully licensed under the statute. I would say that residents are probably not going to be able to do it on a resident license. But I would suspect that when the closer we get to November, the Board of Medicine might have something to say about that as well. But right now, I know it's only limited to physicians. And thank you for reminding me of that. So,
Dr. Heinemann, we have a question in the chat.
yeah.
It says, for opioids, we have to reevaluate at least quarterly. The process with medical marijuana appears to be heading toward yearly, meaning physicians really have no role in managing this. It is more just certifying they have a condition. It bothers me that there is no mechanism to evaluate how a patient is responding.
And that's absolutely true, and that's one of the problems. The other thing that the statute says is you should have an ongoing relationship with the patient. It didn't say you must. I mean, that's the other problematic thing. And they put some of this language, they try to put language in these statutes that keep somebody from blowing into town, getting a hotel room, and then start ordering cards for $150 a visit. So continue to push, and the best lobbying done is personal contact with your representative. So if you have concerns about these things, you all have 2 representatives and 1 state senator that need to hear about what your concerns are. And I would also encourage you to contact the South Dakota State Medical Association, your professional organization, with your concerns, because they're out there working these rules on your behalf. So, and with that, we're at the top of the hour. Do you have any more in the chat?
No.
All right. Well, I thank you for your time. I know this is a little thorny. It'll be interesting to see where we are at the end of this year and what comes out of the session next in January 22. And thank you for your time and attention. So.